Hello students, welcome back to my channel. In today's video, we are going to discuss Order 20 of CPC that talks about judgment as well as decree. But what is a decree and what is a judgment? Hey, before we continue, I wanted to inform you about my live mentorship program for LL.B students or law aspirants. Law subjects and law topics need detailed clarity. We get that with the help of cases, examples and detailed explanation. It's definitely not possible to include everything in these short videos. If you find my videos easy to understand and you are looking for some professional help in preparing for your examination, you can join my live mentorship program. Here you will be getting exam tips, answer writing skills, detailed notes that you can refer for your examination, cases, examples, and in a very easy way topics will be explained. I have live classes going on for a lot of subjects as of now. To know more about it, you can drop me a message on this WhatsApp number. I'm also helping a lot of students in writing their assignments. If you need any such help or for any queries, any suggestions, you can drop me a message on this WhatsApp number. And now let's continue with our video. The word decree is defined under section 2 clause 2 of CPC. Decree is nothing but a formal way whereby court declares what would be rights and obligations of each of the parties. By way of a decree, court provides in detail directions to the parties. For example, you filed a case against me, whereby you get 50,000 rupees from me, and court has given a decision in your favor. In that case, the decree may contain a direction whereby court will ask me to pay you 50,000 rupees. But how will the payment be made? Is it cash? Is it online payment? Is it that at once I need to pay you 50,000 rupees? Or is it that I need to pay you the amount in maybe 3-4 installments? How much will I be paying in each of these installments? In what intervals I need to pay the money? Whether I will be paying it directly to you or I will be depositing it in the court. All these in detailed directions are contained in a decree. On the other hand, the word judgment is defined under section 2 clause 9 of CPC. Judgment is nothing but a formal expression given by the judge, whereby judge will say what is the judgment all about. What is the judgment? Judge has ordered me that I should be paying you 50,000 rupees. But why did the judge say like that? Maybe judge can cite some precedents also, because in so and so case Supreme Court had given this kind of a decision. In another case, this High Court had given this kind of a decision. Plus, we also have this provisions of CPC, that provisions of Specific Relief Act. Considering everything, this certain decision was given. As in, reasoned decision. Judge will provide reasoning why this certain decision is given. With reference to the judgment, decree will be passed. Both of these will have to be in the same lines. Whatever is given in the judgment, in detail, everything will be specified. Rights and obligations will be specified in a decree. When we talk about Order 20 of CPC, there are 20 rules as well. So it's a very detailed, elaborate provision that we get to see relating to judgment and decrees. We also have section 33 of CPC that also relates to judgment and decree, which specifies that once a case is properly heard, judgment and decree will be passed. Judgment has to be pronounced in an open court. It may be pronounced at once the hearing is completed, or if the judge needs some time to write the judgment and everything, he can take some time as well. The judge can fix a next date for pronouncement of judgment, but it should ideally be within 30 days of final hearing. From the date when final hearing was concluded, within 30 days, judgment should be pronounced ideally. But there may be some situations wherein it's not possible that within 30 days judgment will be pronounced. In such a case, the judge may extend this period for further 30 days. As in, within 60 days from date of final hearing, judgment has to be pronounced. But in Commercial Courts Act 2015, we get some additional provisions, some repealing provisions for commercial courts. For commercial courts, this period is further extended to 90 days. Within 90 days From the date of final hearing, judgment should be pronounced in case of commercial suit. Judgment should ideally be passed by the judge who was hearing the case and who has decided the case. But what if the judge got transferred to another court, or might be he retired, or maybe he is not available in the court anymore? He wrote the judgment, but then he is not available to pronounce it. In such cases, the next succeeding judge, whoever is coming in his position, that judge is also having power to sign on the judgment and to pronounce it. Sometimes it may happen that in a civil court, case was decided, judgment was also written. But before the judgment could be pronounced, the court itself ceased to exist. This court is no more in existence. In such a case, this judgment will be pronounced by its next level court. As in, its hierarchy wise, whichever court is coming next, that particular court will pronounce it. As in, this court was subordinate to this court, so this court will be pronouncing the judgment. That provision is also made in CPC. In the first hearing of a case, issues are framed that these 4 points or these 4 issues or maybe these 5-10 issues we need to decide. So how many ever issues were framed, for each and everything decision will be given in the judgment. Rules 1 to 5A of Order 20 of CPC makes provision for judgment, and the remaining provisions are for decree. Decree must be drawn in accordance with the judgment. It will contain the case number, name and description of parties, their residential address, what were claims of the parties, and what relief was granted by the court to them, cost that may be payable by the losing party to the winning party. All these details will be mentioned in the decree. Once a judgment is pronounced, decree has to be drawn as quickly as possible within 15 days of time. But in case the aggrieved party wants to file an appeal, they need not wait for 15 days till decree will be drawn, but they can file the appeal with a copy of the judgment itself. And the Court of Appeal will consider that judgment itself and proceed with the appeal. But once parties receive the decree from the court, they will submit it before Court of Appeal, and Court of Appeal would consider that decree from that time onwards. So that was quickly about what all things we get in a judgment and decree in a civil suit. I hope you found some value out of this video. If you did, do make sure to like this video, share it with your friends and subscribe to the channel. Until next time, bye-bye.